Hello everybody. So this is a discussion on, can patent law be agnostic to the type of technology at issues? So for this discussion, we have Dr. Jay Kesan with us. I switch over to Dr. Jay Kesan. Just before that, I just need to give some introduction for him. He is a patent attorney and professor in IPR and a technologist and a cyber expert. He has more than 20 patents in his name and he has 20 years of experience. I would switch over to the screen to Dr. Jay Kesan. Over to you, sir.
Good evening, everyone. Glad to come to you from my home office in this COVID era. And I hope you're all staying safe and healthy. The topic for our discussion is, can patent law be agnostic about the underlying technology area that it is trying to protect? And it's a really interesting topic because it allows us to explore what role patent plays in different industries. At the outset, as a law student or as a practicing lawyer, you may be aware that the patent laws have certain requirements to get a patent. And those requirements are not specific. They're not specific to a technology area. So these requirements have been harmonized all over the world. So the basic requirements of novelty, utility, and non-obviousness, as we call it in the US, are the same. And they're pretty much the same all over the world, in Japan, India, Europe, US, so on. So novelty basically says that whatever invention you're trying to patent must be new. It also has to be useful. And it has to have an inventive step, as the Europeans call it, or it has to be non-obvious, as the US calls it. So that means that even if your invention is new, but if it is some obvious combination of what is already known, then it is not patent eligible. Of course, not obvious to you and me, but obvious to a person in that field, a person of ordinary skill in that particular field that the patent pertains to. Now, so very often this non-obviousness requirement is thought of as how the law defines the word invention, meaning that if something is not obvious, then you have actually invented something. If it is obvious, then in the eyes of the law, you've not invented anything. So this basic requirement of novelty, utility, and non-obviousness must be satisfied by any patent. Doesn't matter if it is a patent that's directed to some coolant, a new type of coolant that's used in an air conditioner, or if it is a new drug, or if it is a new touch screen for your smartphone, or if it is a new kind of display, or if it's a new kind of computer chip, or a new kind of technology employed in 5G. For every one of those different technological areas, the patenting requirements are basically the same. Having said that, what is more interesting perhaps from a sort of practical standpoint is that the value of a patent in these different industries is actually very different. Let's take an example. So if you were to look at something like a smartphone, it has literally hundreds of thousands or 100,000 or more patents that are embodied in that phone. All aspects of it, all the way from the details of the specific baseband processor and the computer chips and so on, all the way to the touch screen on the outside and everything in between, and of course all the wireless technologies that are employed in communicating various kinds of modulation schemes, coding schemes, and so on. So there's a lot of patents involved in something like a smartphone. In the other extreme, you take something like a new kind of pharmaceutical, a drug, let's say some drug for, reducing, acid reflux, something like that. The number of patents that are involved in a pharmaceutical drug like that is very few, typically 3, 4, 5, 6 patents. So on one hand, you might have something like a smartphone with more than, 100,000 or more patents. And then you have something like a pharmaceutical drug with about, less than 10 patents. So now you can see that the value of each patent as a result is very different. Why? Because a small number of patents contribute to the innovation and are responsible for the sales of a drug. And so each patent becomes much more valuable compared to 100,000 or more patents in the case of a smartphone. Of course, there may be a few patents, even in the case of a smartphone, that are very valuable. But generally, on average, each patent is much less valuable. Typically, in the case of a pharmaceutical drug, you may have a patent directed to the formulation. You may have another patent directed to the method of producing that drug. You may have another patent directed to the coding, or another patent that's directed to the way the drug is delivered into the human body, so on and so forth. So the interesting thing is that depending on the kind of technology that is involved, the value of the patent in that field might be very different. One of the consequences of that is that in the pharmaceutical, life science, and biotech space, broadly speaking, there is a lot more effort and money spent even trying to get one patent. And of course, I'm comparing this to, say, a semiconductor patent or a wireless computer chip patent, and comparing that to a life science patent. In addition, litigation involving the IT sector patents versus litigation involving the pharmaceutical sector is, again, because the stakes are higher, there is often more money spent on life science litigation in each lawsuit. If you compare one lawsuit to another, just as you compare, the amount of money spent prosecuting one patent in one field versus another. Another way of thinking about this is, let us step back and let's say you're a company that is innovative, and you're innovating in the IT sector, you're developing new computer software. And imagine, on the other hand, there's another company that's developing a new pharmaceutical drug. If you ask yourself, if you're an innovative company, how to get rewards from the market for your innovation? In the IT sector, you have a lot more ways to benefit from your innovation compared to the pharmaceutical sector? Well, think about this. Let us say you have developed a new kind of application, and it's some sort of application. Let's say it's a new kind of word processing software. You can introduce the word processing software and you may be able to patent it. But ultimately, in a networked industry, it's really important to have users, right? In a networked industry like computers and communication, it's really important to have users, and you have to build up your user base. So getting to the market and building your user base is almost more important than getting a patent. So for example, even if you came up with a new kind of software technology, somebody would not be motivated to switch to your application if enough other people are not using it. So think about this. Your word processing software, something like Word, is valuable to you because lots of other people are using the same application. So then you can share documents, etc. If there were only 10 people using the same software application, it would be less valuable to you. What you have is still the same piece of software, but depending on how many other people are using it, it becomes more valuable to you. So that is the so-called network effect in the IT and computer sectors. What I'm trying to say here is that even if you have a patent for, or many patents embodied in your software, that is just not as important as having patents for a pharmaceutical drug, because network effects are more important. And in fact, moving first into the market and locking people in can mean that even if you don't have patent protection, you might still enjoy a lot of benefits from the market. It's considerably less so for a pharmaceutical drug. Think about this. If somebody were using an older drug and they were suffering from acid reflux, and you come up with a new drug, a new medication, and if that has some lesser side effects or if it is more effective, they'll simply switch. They'll simply switch to the new drug. It really doesn't matter that much whether other people, how many other people have used the old drug or not. Of course, many other people have used the old drug, then you have a better idea of the side effects and so on, but it doesn't affect your utility from the new drug. You can simply switch. That is not the case with IT. So you can see how patents, in fact, play a lesser role in the IT sector compared to, say, the life science or pharmaceutical sector. In addition, the speed of innovation in the IT and pharmaceutical sector is such that your patent protection is valuable only for a smaller number of years in the IT and software sector before something else comes along, as compared to the pharmaceutical sector. All over the world, the patent term is harmonized. It's 20 years from the date of filing of the patent. The patent term is harmonized. However, you have to pay certain fees, and they're called maintenance fees. In many countries, you have to pay it annually, so they're often referred to as annuities. So you have to pay them every year to keep the patent alive. In the United States, you have to pay 3 times at the end of 4 years, 8 years, and 12 years. So you have to pay 3 times to keep the patent alive. Now, in the IT and pharmaceutical sector, the number of payments vary greatly. So, for example, in the IT sector, people will pay the first maintenance fee after 4 years, but a lot of patents, they won't pay the second maintenance fee at the end of 8 years. And for an even larger number of patents, they won't pay the third maintenance fee of 12 years. So that is less so in the pharmaceutical sector. In the pharmaceutical sector, people tend to pay all 3 maintenance fees and keep their patents alive because the lifetime for the drug is longer. And in addition, there's another important point, and that is they have to go through an application process with something like the Food and Drug Administration. So there's a regulatory approval. So even though you got the patent, you have to go through the regulatory approval, which may be many, many years before you can introduce the drug to the marketplace. So then very often, the later years in a patent are more important in a drug compared to IT because you have to wait so long to introduce the drug into the market. So very often, the period of time between 15 to 20 years might be very important for something like a drug and less important in the IT sector where innovation is faster. So I will stop here and we can take some questions.
So that was very interesting, sir. So I have a few questions for you. So does an attorney can specify his practice to a particular technology of an area where patent law is higher payable for him?
So that's a really, really interesting question. So I guess the question really comes down to, if I am going to practice in IP, then should I be practicing in the IT sector, or should I be practicing, say, in the life science sector? Now that's fascinating, but in reality, what happens is that it really depends on your education and work experience. So what ends up happening is, let's say, you have a background in computer science or engineering, then, you may end up having more IT clients come to you. Whereas if you have a biology background or a life science background, you may end up having more life science companies come to you. So that's on the education side. If you simply have a law degree and you don't have any specialized science or technical background, once again, you may have some work experience. And you may have dealt with many cases in the IT area, or you may have dealt with many cases in the life science area. So then your experience also tends to take you one place or the other. Now, the point that I'm trying to make here is that it doesn't follow that therefore you're going to make more money necessarily if you're in life science or in IT. So take, for example, yes, you're preparing a patent application for a biologic or for a pharmaceutical drug or for some innovation related to genetics. It may take you more time. So one patent application may cost you a certain amount of money, but it'll take you more time to do it. Now in the IT sector, maybe for the same amount of time, you might be able to file 3 applications instead of 1 application. But the amount of money that you've earned is still basically the same based on the amount of time you have spent it's just spread across 3 applications in the case of IT, whereas it's 1 application in the case of biotech. You know, and but your billing rate and the amount you charge might be different in each case. In one case, it might be 3 times more than the other, but based on the amount of time you spend, it's not like you're making more money. Does that make sense?
Yes, yes, definitely, it makes sense. So, does a country, you know, make policies for, you know, enhancing a patent policy for a particular technology, particular area of technology? Does a country do that for, you know, for getting revenue or something?
So again, that's again another very interesting question. Um, so think about it this way: from an economic development perspective, you know, a country might be interested in protecting its innovation. It might be interested in encouraging its industry. And IP policy and patent policy is a very important knob that a country can use to encourage innovation in a particular sector. So, for example, in India, there's a lot of software companies, there's a lot of computer-based technologies, and it might make sense to have better protection for IT and computer-based technology. You know, that might make sense. And, you know, in fact, that would then result in more investment and more investment in innovation in that sector. Now, in India, on the other hand, in the pharmaceutical sector, the Indian generic companies are very, very strong. And they might view patent protection for pharmaceuticals as not a benefit, but really a hurdle. You know? And on the other hand, if you want to have innovation in the pharmaceutical and life science sector, then it might make sense to have better patent protection for pharmaceutical drugs, etc. Because you already have a good, thriving generic industry that's doing well. So it might make sense to encourage smaller, newer companies that are doing more research and innovation in pharmaceuticals. So you make a good point, and that is that patent policy across different technologies might actually be something that a government might want to focus on, and it might want to use and deploy effectively as part of a national innovation policy and as part of an economic development policy. Does that make sense? Does that make sense? I guess we may have lost, momentarily, we may have lost Arpana there. I noticed that I have a question.
No, sir. I'm here, sir.
Oh, okay, okay.
Yeah.
Yeah, go ahead, go ahead.
So, yeah, sir. So there is a question from Mr. Nitish Bagri. He says, patent law and procedure is not universal across all countries. How do you see that? An opinion or a failure, an opportunity or a failure? So,
That's a very good and a very complex question, actually. So, in fact, the patent laws on the acquisition side, on the side of getting a patent, the requirements to get a patent are actually quote unquote universal. They are harmonized because there is something called the Patent Cooperation Treaty. So that means that if you are an Indian company and you file for an Indian patent, you can then file a single application to protect yourself in other countries. So you can file something called a PCT application. And the requirements that I mentioned at the beginning of the talk of novelty and utility and non-obviousness or lack of inventive step is uniform. So it allows you to get a patent in multiple countries where the requirements are really not that different. There are small changes, so on. Of course, you have to translate your application into the language in the different countries and so on. But the requirements are not that different. Now, when it comes to enforcement, that is where the real difference comes in from one country to another. So in the first step of acquiring a patent, it's not that different. But when it comes to going to the courts to enforce the patent in an infringement action, that is where the differences come in. So for example, in India, it's my understanding that in many patent infringement cases, the plaintiff will move for a preliminary injunction, will go to the Delhi High Court and try to get a preliminary injunction. And many times, the court will actually award a preliminary injunction. And very often, after the preliminary injunction, after a little while, the parties usually reach a resolution and they settle. So it doesn't even happen that you have a full-blown trial. In the United States, injunctions are largely quite hard to get in patent cases. So the way the litigation proceeds is very different. But now, having said that, there are some commonalities too. Like in India, also, a defendant can go and challenge the patent in the patent office that handles post-issuance invalidations in Chennai, for instance. So in other words, when A sues B for patent infringement in India, B can go to the patent office and can basically say that patent is invalid and should not have been granted in the first place. So you can challenge that. Now the similar procedure exists in the US as well. So same thing, if A sues B in the US, B can go to the patent office and can go to something called the Patent Trial and Appeals Board, it's called the PTAB, and argue that the patent is invalid and should not have been granted in the first place. In other words, the patent is not new and the patent is obvious, for example. So you can see how the patent acquisition side, the rules are harmonized, but on the enforcement and infringement side, they're different. But having said that, there are still some common features. As I pointed out, there are some common features relative to challenging a patent by going to the patent office. The same thing is true in the US and in India. So the answer is that it is complicated. There is room for harmonizing the enforcement side more, and that will certainly help the patent system. That will certainly help in a big way. I hope that answers your question.
Definitely, sir. So that was great. Sir, we have another question from Radhika Kothari. She is asking, how do you see the trading of patents? Ethical or just a business opportunity?
So, yeah, it's a little bit off from our topic, but I'm happy to sort of answer the question. So the issues that come up with licensing patents or using patents to finance your company and so on. These are all common ways for a technology company or for a life science company to get revenue and to attract financing. The ethical issues often come up in the context of access to medicine. That's where very often so there is not that much of a controversy on the IT side. On the IT side, there is some, but there's not as much. The real ethical concerns come in when patented drugs cost more or cost much more than generic drugs. And so should that be permitted or not permitted? And that is where the sort of the ethics issues come in. And the answer to that is, of course, quite complicated, because you certainly don't want people to die because they don't have access to medicine. Hopefully, it doesn't come to that. There are sometimes you will find opposing points of view. Some people say, yes, we agree that the price of drugs should not be so high. But then the question is, who should pay for it? So some scholars suggest that the government should subsidize the price so that the person who is manufacturing the patented drug still gets some reward so that they can continue to do research and continue to develop newer drugs in the future. But at the same time, the person who wants access to the medicine doesn't have to pay. In other words, if something costs $10, then, and if the person is able to pay only $5, then maybe the other $5 needs to come from a foundation or needs to come from a government, etc., so that the person who only has $5 is able to get the medicine. At the same time, the person who is manufacturing this, it's their new technology, it's their new innovation, it's their new formulation, is still getting some benefit. So I think there is a real debate about what should be good policy, but it's really in the access to medicine category that some of these questions are raised. I hope that makes sense.
Yeah. Radhika have saying she also having a question like she doubted that does this liability give additional problem to the developing countries, that there will be liability to the government, right? If these kind of ethics are followed, so it will differ. It would be very difficult for the developing countries. It would specifically affect the developing countries, right. I guess, right?
So that's a hard question, and it really depends on a nation's policy. So on one hand, a country might say, well, we don't recognize patents on these medicines, and that may mean that they may not get access to those medicines, or they may not get access to those medicines right away because the pharmaceutical company may not sell in that country, and they may have to wait until the generics are produced, and at that point they might set aside those drugs, and for that period of time between when you have the patented drug and you have a generic formulation that works just as well, for that period of time you may not get access to that medicine, so there may be a loss there. On the other hand, once the generics come in, then you do get the drug cheaply, but it also means that in the future, they may continue to have the same issue and the same problem. So A better way might be to try and work out some solution and perhaps even try to go and see if there are certain international foundations or other places that might subsidize the price of that drug so that you can get it. So it doesn't have to be additional liability on the part of the developing country specifically, as you have suggested. So I think it's more complicated, but I can certainly understand that, hey, if there's people who want access to this cancer drug and they're simply not able to pay, that puts a lot of pressure. It puts a lot of pressure on the government to try to make that medicine available. And so you have foundations like the Gates Foundation and Rockefeller Foundation that are trying to address these issues. And they're trying to make it possible to increase the dissemination. At the same time, try to preserve some of the incentives to continue to do pharmaceutical innovation by the pioneer drug companies. So that's the balance that we're trying to achieve.
Yeah. So we also have one more question from Bharat M. He asks, so the difference in the procedure across the nation attracts growth of unethical business?
So, that's again a very good question. It's, so think about it this way, right? Justice delayed can be seen as justice denied, right? So if you are a patent owner and you bring a lawsuit for patent infringement, if that goes on for 10 years or 15 years, you're going to be unhappy. Because you're saying, hey, I have a genuine patent, I have a genuine invention, and you are infringing my patent, and you are selling this stuff, and you're making money, and I don't have any way to stop you. And when I go to the courts are taking forever. This is crazy. So that is the perspective that you will often hear from a patent owner. And I think that's what you're referring to, where you're saying, hey, these people are infringing and they're doing some unethical business. And I understand. I appreciate what you're saying. Now, in the Delhi High Court and in other high courts in India, that's one of the reasons why in making these kinds of arguments has meant that patent owners actually can get injunctions. They can actually get a preliminary injunction to stop the defendant company. And so that forces them to come to the table and work out a solution. Because in most patent cases, what are we talking about? We're talking about a reasonable royalty. And in most cases, what's a reasonable royalty? Instead of making 25% profit or 20% profit, you're now maybe going to make 19% profit, because you have to give 0.5% or 1% to some patent owner who says you're taking my technology. So it's just a question of coming to some sort of compromise that you can live with. Maybe your profit margin is reduced a little bit, but that's about it. So, however, if enforcement is a problem and enforcement is not uniform, or even if you get a judgment in one country, you may not be able to enforce it in another country. All of these kinds of problems means that, yes, you are exactly correct, that sometimes defendants can get away with infringing conduct, and they can take advantage of the fact that courts don't move quickly, so on and so forth. And you have the idiosyncrasies of different countries. Now, you have a similar problem in Europe as well. So, for example, you can go and apply for an EP, for a European patent, and you can get a European patent that is then valid in Europe. But in order to enforce the patent, you have to go to the individual courts in the individual countries. So if there's an infringement in France, you've got to sue them in France. If there's an infringer in Italy, you got to go sue them in Italy. If there's an infringer in the UK, you got to sue them in the UK. So now you chase all of them down, and now you once again face the vagaries and the idiosyncrasies of the courts in each of those countries. And so once again, you know, you have similar problems. So the point you're making is a very valid one.
Thank you, sir, for the answer. Sir, Arpit Booth also have some question. He asked, how can technology protect traditional knowledge over illegitimate and unfounded intellectual property rights?
Right. So that's again a very good question. And you guys are all asking excellent questions, really. So in fact, traditional knowledge has actually been used to invalidate patents. This has actually happened. So there was a period of time in the past where, because some of the traditional knowledge was not written down, you did not have publications and so on, and it was sort of word of mouth and people just talking. So nobody really knew what exactly was that traditional knowledge. But things are really changing. So for example, traditional knowledge from India has been used to defeat patents several times in the United States. And the patent office has found, you know, whether it's neem and whether it's the neem tree and whether it's the medicinal and therapeutic properties of, you know, particular plants, particular herbs, and so on, and particular kinds of medicines that are a combination of plants and herbs. And these things have actually been used to invalidate a patent. Now, so the actual medicinal substance, it has been argued, is known. So that then defeats patents on that substance because it's not new anymore. Remember, I told you one of the basic requirements is that it has to be new, and this is not new. So that's been the major argument. Now, the follow-up that has happened in many situations is that the pharmaceutical life science company will do additional research, and they will find out what is it that is the ingredient or the molecule or the compound in some tree, in some leaf, in some root that is responsible for the medical, for the medicinal outcomes, for the favorable outcomes. And then they will artificially make that in the lab. So in other words, now you don't need that particular tree anymore. You can actually make the drug just based on the compound. So everybody can enjoy the benefits of that medicine, not just in areas where the tree grows or how long it takes for the tree to grow, etc. So the artificial making might then be the subject of a subsequent patent. So you often have situations where you may not be able to get a patent on the original composition anymore, because that's not new, but subsequent artificial methods to make the same thing might be patentable. So does that make sense?
Yes, sir. I hope Arpit Booth's query has been resolved by the, yeah. Yes, he answers.
Yeah, so I see a nice comment about like the turmeric latte. Well, so that turmeric latte brings up an interesting different point. So this is very interesting. Yes, lattes are known, turmeric is known. So really putting some turmeric has actually also been used, by the way. Turmeric has also been used to invalidate patents because the healing properties of turmeric have been known for centuries in India. So you put your turmeric latte, yes. But the interesting point is the turmeric latte brings up a different issue, which is another kind of IP that's trademarks. So yes, the turmeric latte may be known, so you can't get a patent. But then if you start selling the turmeric latte and you start having a brand so that people recognize, aha, that turmeric latte comes from that company that is making it, and they make really good turmeric lattes, then you might get trademark protection for it. But that's the protection for the brand. That's not the protection for the composition or for adding turmeric to milk. It's because of the advertising and branding that has created this association in your mind that their turmeric latte is very good. The turmeric latte from that company is very good. So trademark law protects that kind of thing. So you might be able to get, even though you cannot get a patent, you might be able to get a trademark for something like a turmeric latte because it's coming from some particular company that's selling that. I hope that makes sense.
Yes. So, Arpit would have one more question. Let us start. Yeah. So he says, nowadays every notion is exploring the space. So in that context, whether the protection and enforcement of intellectual property rights may conflict with these set fundamental principles in the terms of access to knowledge and information derived from the space.
So that's again a very good question. Now that is a truly unknown issue because space law is just being defined right now. So it's almost like that's the the frontier of some territory where you basically, human beings have never gone there. Right. So you have this question of who has the rights to there and who lands up there for the first time and who gets, so it creates a whole new set of interesting questions about how you come up with property. How can you even think of property in those circumstances? And is it simply possession that is responsible for all kinds of property rights in that situation? So that's a very good question. Absolutely, interesting question. So how are we going to even create and define property rights and property norms? I'm not talking about technology. I'm talking about even physical. It just simply is possession. The 9/10 of the law, as they say, you just go there in space and grab it, and now it's yours. So that's truly an emerging area. I agree.
Yeah. I guess common heritage of mankind is one of the principle of space law. So if anything, come up, we could implement that principle there.
Right.
Yeah. Rather than asking for any right over there over that specific area.
You're right. Now that is certainly true with respect to space. But having said that, many of the vehicles and many of the technologies that take you to space are in fact the subject of patent. So just so we understand, all those various kinds of lubricants and various kinds of rockets and various kinds of fuels and various aspects of space shuttle and various kinds of how to maintain the enclosed space and all that are the subject of a lot of innovation by many companies all over the world. And a lot of those things are patented. And some of them have also been held by companies to be, have been held by countries to be matters of national security. And it has not been revealed and so on. So yes. Yep.
So any more questions from the audience? So it's been 1 hour. So let's, if there is no question, then we can end the meeting now. Or if anybody has a question, please raise the question now.
Yeah. thank you so much. This has really been exciting. As you can imagine, talking about intellectual property rights and patent rights and so on is actually tremendously interesting. That's really my main goal here is to make you excited about thinking about IP and thinking about patent rights and thinking about technology and thinking about innovation is really worthy of your best efforts, worthy of thinking about it, worthy of practicing in this area, and that's really my ultimate goal here. So thank you for listening, and hopefully we'll talk again.
Thank you, sir. Thank you for the time.
Indeed, and I'll end the session now. Thank you.
Yeah. Thank you.